Hi, it's Tony here again from Estate Planning Solutions. Last video we got you to focus on yourself and look at the difference between having your will done by a non-specialist and a specialist. As I said at the end of the last video, we're going to have a look at what happens when you separate and how important it is to get your will done quickly. So, real life situation which is happening today is that people separate, and you may still be married, but you've separated and you haven't changed your will. So here's what can happen if you don't. In a case that recently occurred, a hubby and wife split after a long-term marriage, and they instigated family law proceedings. And during the time of the family law proceedings, the husband passed away. So what happened is family law proceedings were ceased immediately because they absolutely became irrelevant. And what was discovered is that the husband hadn't changed his will. Now everything ended up going to the wife. Remember, prior to his death, they'd instigated family law proceedings because they wanted a financial separation settlement. Now, what happens in this case is it raises the issue: does your financial planner, does your lawyer have a liability in this case? As it turns out, they may have. And in the 1997 case, which again you can go and look at yourself, which is Hill and Associates versus Van Earp, it was revealed that the planner and the lawyer do have a case to answer, because they need to be on top of these sorts of things. So if their client separates, they need to give you the advice that, hey, you need to go and change your will pretty smartly. And the reason being is it's quite simple, is that once you separate and you change your will, obviously your beneficiaries are likely to change. Instead of everything going to your spouse, it's going to go to maybe your kids or somebody else. And where the liability for a planner and a lawyer come in is that by not giving that advice to their client, that is the planner or the lawyer or both, they actually may have unintentionally caused what's known as a disappointment to beneficiaries. So in other words, if the planner or the lawyer have failed to give you the advice, if you've separated, that the implications of taxation, if somebody was to die during family law proceedings and it hadn't been finalised, it's quite possible that a future beneficiary, someone who was intended to be a beneficiary out of the separation, could become disappointed. Now, they become disappointed means they may have the ability to put in a claim. Again, another dimension of this interesting world of wills and estate planning, but one that is really important. So if you know, if you've separated and you haven't changed your will, or you know somebody that has, it may be time for them to get in contact with their planner or their lawyer if the planner and lawyer haven't made contact with them, for two reasons. Number one, to get the will sorted out, and number two, assist the lawyer and planner from a possible claim in the future if something was to go wrong before family law proceedings were settled, so that they didn't become liable. And that's what we want to chat about this week. We'll catch you next time.